Thank you to the organizer, EPRS, and the other units that have been involved in organizing this conference at the European Parliament. Thank you to the staff and thank you to the audience for having me this morning. I was asked to entertain you on, on the topic of closing the policy cycle because in the program I sit between day one, that is more ex ante, and day two, that is obviously on policy evaluation and legislative regulatory review. So see what can we do in between and throughout the different stages of the policy cycle. I'm not sure where, yeah, I can control my slides from here, and I press strongly. Okay, so when we talk about those are just to clear my throat and make sure that I have the same language that you have. I think that closing the policy cycle is more than a mechanistic imperative. The notion is to create policy learning across time. And in terms of motivation, in terms of core principles, since the reform brought about by Frans Timmermans, there is this principle at the EU level of evaluating first, and something that the people in the next panel will certainly talk about. So evaluating first means to carry out an evaluation before starting work on new policy proposals. Consultation over the last 10 years has evolved from a specific step in the policy cycle to a continuous activity across the stages of policy formulation and decision-making, at least at the EU level. Another important element of the picture is obviously regulatory oversight. The Regulatory Scrutiny Board of the European Commission over the years has taken on a number of tasks that were not originally envisaged, from the initial task of checking the quality of impact assessments to evaluations. And now, since 2020 January, at least on paper, we heard yesterday about the use of Foresight in evaluations and impact assessments. So that's a new expanded mandate of the Regulatory Scrutiny Board. And finally, just before the COVID crisis, as we had yesterday, we had Foresight as a principle that has been not just added to, but kind of inserted into the notion of policy cycle. And as we said yesterday in many interventions, this is not just another tool that goes down the list of the other tools for policy making, but rather a way of reasoning, a way of stress testing, a way of thinking. So what I want to do now is to take this principle and more generally the notion of anticipatory policy making as a starting point and make 5 points that hopefully are useful for our discussion. So let's belt up and see what the 5 points are. Let's put them out together. I will speak for 60 seconds on what the policy cycle is, just to avoid me being misunderstood. Maybe we think differently. And then I spend most of my minutes on policy coherence, obviously very desirable, but many years ago, a colleague, Grant Jordan, wrote about the incoherence of policy coherence. So things can go bad, even in the field of policy coherence. And we see why and how. The ecological thinking is my third point, and then I will raise 2 issues about the dilemma between controlling or guiding, so monitoring versus learning, you can also call this point. The final point will be very short on what we do with anticipatory policy making in relation to the crisis, and we absolutely cannot do. It's just impossible, at least in my view. Okay, one thing only on the policy cycle. The policy cycle does not exist like an entity that we go out and we measure in days, in months. The reality of policy making is is a reality of a process with multiple cycles where even participants, fora of discussion, decision-making venues change through time, so we cannot imagine drawing a line. I came here with a good friend and from the Commission was talking to me about a process that lasted 9 years, and that was not the longest. So when you think, what is the cycle here, you have to think about, for me at least, the notion of policy cycle, rather than being a realistic description, is more a way that helps me to organize the tools and carry out the regulatory management and oversight. It is a way of organizing principles rather than something that starts neatly on day 1 and ends on day 22. It's not a film with a beginning, at the end, and the end credits. So like watching different films at different times in the same room. Okay. So now the big topic, I heard a lot, there is also a United Nations guidance note, very well done on policy coherence, and that I think is what is behind our difficulty of putting together the tools and the principles of anticipatory governance. Now, the first level of coherence is coherence across the tools. And here we heard yesterday in a wonderful panel the discussion about impact assessment and foresight. Obviously, most of cost-benefit analysis comes from retrospective data that are then interpolated. They are then shown to evolve according to likely impacts. And that's obviously, I mean, when I started teaching benefit cost analysis was don't go beyond 5 years, because then it's just guesstimates, between a guess and an estimate that doesn't mean anything. Technology changes, the world changes, but that's exactly where anticipatory policy making starts for. Yeah, technology changes. How does it change? Who are the missing stakeholders that we're not considering today, but will be important stakeholders tomorrow? So this is a difficult balance. And yesterday we heard, I have a reference to your note of the EPRS, how the European Commission is using, and the Scrutiny Board is using foresight in impact assessment. We heard there was one case in which it uses a stress test, then we have the more usages of the mega trends, and also one way, if you think with the Commission's hat on, is not a bad idea to commission a study for foresight, and that is frequently done. Question is how you bring them together, and the Commission at the moment is not accountable for using foresight and not using foresight one way or the other. Is that a bad thing? One could say no, because this belongs to the right of legislative initiative of the Commission, so it's all done in the name of right to initiate legislation, and the Commission cannot be accountable for every single decision taken. But I heard yesterday a big word, transparency. So the Commission, I'm not saying accountable to someone for using or not using impact assessment and foresight, but I'm saying transparent on the reasons why. No, the same way that sometimes we read this proposal as no impact, assuming that on gender, okay, because we looked into that and we found that there is no gender dimension. That's more reassuring than just not seeing, in this case, foresight, so then we speculate about the reasons of why foresight is not there. And the key role here, the role of the Regulatory Scrutiny Board, and I think the services of the Commission have some uncertainty about what is the level of foresight that the RSB wants. The RSB looks at evaluations and impact assessments one by one. So there is no a general level. There is an appropriateness judgment that the RSB produces on each and every document that they are examining. But the guidance note is only available in the better regulation toolbox. So maybe the RSB could do some guidance notes on how they see things. I think here the key job is to stabilize the expectations of the services so they know, when is that the RSB considers useful this level of evidence in foresight, for what reasons. And what we do at the moment, thanks to EPRS and others, is to read all the decisions of the RSB, and like you did in your note that is available outside here, provide a compendium of the things said by the RSB. I think that's the best we can do at the moment. So to conclude on this, I think in the future we're going to see more transparency in how the Commission makes or does not make use of foresight in impact assessment. Now, more difficult, we're going up, raising the bar a little bit. Coherence in modes of reasoning. That's more difficult. I wrote a paper with a colleague, Laura De Vito, on foresight not being just another brick in the wall, not being just another tool. So it's an organizing principle, fine. Everyone is happy with that. Oops, back one. Okay, this one. So if it is a way of thinking, I believe that we all agree on this slide that foresight should help us to organize big chunks of legislation in terms of whole of government thinking about the chemical strategy, about the Green Deal, about a number of big elements of the digital and ecological transition of the EU. So it's not just the tool that you use in impact assessment number 22, it's also a way of organizing big chunks of the legislative cycle, of giving coherence to this, because they're all projected into a foresight thinking. The question that I don't have the answer, maybe in 3 years or 5 years we'll have the answer, is this really how foresight is used for these big elements of legislation? Are we using foresight to organize the Green Deal legislative production? My feeling is no, but I haven't done research. I mean, certainly it would be very good to see foresight used to bring coherence at this level, not inside an impact assessment, but inside a legislative cycle. And maybe there is a job also for those who monitor the RSB in the first place and the EPRS from the Parliament to answer this question, whether we are using foresight a bit more strategically for this purpose. At the moment, my honest answer is that I personally do not know, but it would be very desirable. And again, going up on these modes of thinking, foresight is a way of reasoning about the future, of taking into account some important elements of transformation. There is still an ambiguity in reality. It's not that someone is ambiguous, it's reality. There is ambiguity in whether we use foresight to pick, we heard yesterday from Stephen Quest, something very interesting about it, to pick the most desirable scenario, and I can see all the heuristics, our mind that goes in that direction very clearly. And using this, that's desirable, so we steer all the legislative production in that direction. That's how I did some of that with companies. That's, we like that one, and we have the power to get there. So you use the most desirable, then to move all of your resources, your marketing, your R&D. I don't think that's the only way you use it in politics, right? Outside the corporate world. Another way is to use the foresight to see the scenario that best balances regulation and incentives, or if I may use different words, precaution and innovation. So there is a tension always, and we are there at the moment, so from the stress test, which is the most undesirable scenarios, to the most desirable, foresight, what I want to say is that has to find a place when we think big about the legislative production, and there has to be some clarity. So if it is a stress test, it's certainly not the most desirable, but if it is the most desirable, then it's not the most balanced, and we have to raise questions about, okay, so we are in a steering mode here, and when you steer, you can expect conflict, and therefore, how do you handle that conflict? Again, transparency can do a lot here in terms of clarifying the usages of anticipatory modes of reasoning. Okay, what else is needed to achieve coherence? I'm almost done with this coherence story. It's very difficult to imagine all these, now that we have a Foresight and administrative burdens reduction systems, and we have impact assessment evaluations, to think of all that going on without a general EU principles of administrative law. And that's something that the Parliament has been struggling for decades, right? The EU APA, Administrative Procedure Act. But if I were to look at countries where the APA exists, there in the general law of administrative procedure, I would find all what I was asking for before, and the transparency and the discretion and who does the monitor. Usually, all these big tools that we're talking about are accommodated, described, and governed by a general law of administrative procedure. And it's been an uphill struggle for many, many years and maybe that's the moment to rekindle the debate on what is the general architecture of administrative law into which these tools and modes of thinking should work. And talking about modes of thinking, again, we have to reconcile benefit-cost thinking, which is a way of thinking and reasoning about evidence, with foresight, that is also about thinking about evidence, but we cannot have an impact assessment that thinks in one way with benefit-cost analysis, where the way I see all the benefit and cost come maybe in range, but that it's difficult to find cases with attached probabilities, and foresight that is a probabilistic thinking. So once I spoke about probabilistic cost-benefit analysis, and they told me it's impossible, but if we never try, we will never know what that means. But clearly, this reconciliation is still a little bit a way forward from what I see today in practice. Now, there is also the question of the final step, how we use foresight, right? There is, I think, because of the way the mind works, a tendency to use it prescriptively. We have foresight behind us, so we use it to make the decision, and it's inevitable. It's a European Commission, we're talking about institutions here, it's the EU. So this prescriptive power, however, I don't know how, but it should be limited, and there must be a little voice saying, not so fast, right? Not so fast. Because if you use it in prescriptive ways, like to steer the economy, because it's the scenario we want, then you need agility at the same time. As we said yesterday, I think it was Trish saying we should do it for 2 years and go back, look at the plan is wrong. And so agility, however, the way we do it that's probably something interesting for you. We have a system of courts and a business community that loves legislative stability. So it's not like with the Australian regulators that can change with guidance notes. Here, everything goes to courts. So this agility by exception clashes with adversarial legalism, with a number of cases taken to courts about this agility that looks good here, but in court can be a problem. So how do we say, this is a contradiction, that we sometimes may use foresight to promote the green ecological transition, because politically we want this to happen. So that's a prescriptive use. Then we find that reality moves differently. We go back and we have agility by exception. We revise the plan as we see fit. Accountability at this point goes down to zero. The courts come in. Yeah, you can see the mess that happens with agility by exception. And there is a lot of interest on adaptive regulation, agile, all good Anglo-Saxon concepts that do not sit well with the jurisprudence of the Court of Justice of the European Union and with the way courts work here. But instead of leaving to the courts, if we go in the direction that Tricia and others were saying yesterday, maybe we should own this process of embedding agility into the usage of foresight and try to avoid the courts making decisions for the policymakers. But just go back to the preconditions for this mess to happen is to use foresight very prescriptively at the beginning, say, we have to go there. It's a political decision. And then try to insert agility case by case, by exception. Okay? Then, what have I learned about this stuff? I learned from a project that we just finished and we're writing the book that we should never think about effects of these instruments like impact assessment evaluation on their own. The overall effect that we measured is ecological and includes also the Ombudsman and Freedom of Information Act. So each of these tools, impact assessment, evaluations, has a very limited effect on, or zero effect, on final outcomes. By final outcomes, I mean we looked at perception of corruption, business environment, and environmental performance. Obviously, we improve our regulation because we want to create a better business environment. We had a transparent consultation because we want people to have a perception of transparency and fair access to the policymakers. But in this project that has looked at all the 27 member states of the EU, the only effects that exist in the numbers that we have are kind of ecological. So, and they go beyond what today is better regulation. And I know that we must have a panel on evaluation, one on impact assessment, one on foresight. But again, I go back to the notion of what is the overall administrative procedure, what is the EU model. We cannot never stop one day and say, okay, what is the system here beyond the individual tools and modes of reasoning, and what are the effects of this system? So this thinking ecologically can also go a long way in terms of regulatory oversight, right? Because that would be something that the Court of Auditors has done in the past to look at the overall system of evaluation and the overall system of better regulation as a system and not as a collection of individual tools. Because finally, the tools may contradict each other. I am a strong believer in the fact that administrative burdens reduction plan or a standard cost model within impact assessment are they destroy the logic of impact assessment. They are enemies of the other instruments. So there are also these coherence moments when you look at how different tools interact. Okay. And that brings me to, okay, if there is a system, what is the way of steer the system? I think from the member states, every time they speak, they want more control, more independence, stronger review of what the European Commission does. And that's monitoring, controlling, but too much monitoring stifles learning, improvisation, the moment, innovation, creativity. So another role for bodies like the RSB is to guide officers, to help with learning, to stabilize expectations, to make clear what is the level of evidence, to show how things should be done. Obviously, that's something the RSB already does in a small part, but I think the big desire of some delegates of the member states is always to see the RSB saying, no, more times, and be stronger and demand more. And that's one way of doing things. The other instead is to make sure that the people who are doing this stuff upgrade their skills and therefore can raise their own bar. Let's now restart the computer now because you don't want to listen. I think there is only one left. So control and gather is the dilemma of managing the system. Do I manage the system to control it to death because I don't trust anyone? Or do I trust a little bit the services and those who do this stuff and I want to guide them and assist in their learning process? And then, obviously, we talked yesterday about the crisis, and I think in this room we are all clear that that's a problem of not selling what we are doing here as a way to avoid the next crisis. That would create a lot of frustrations, but rather it's a kind of logical preparation on the one hand, and secondly, the better regulation thinking during the crisis. Obviously, you cannot have 12 weeks of consultation during a crisis, but you can have risk thinking. And, you put children out of school and you put them at home with the grandparents who are the most likely to be infected and suffer from something like COVID. So this kind of displacing risks and probing evidence and listening from feedback is particularly important also during a crisis, rather than saying we're doing all that to avoid the next crisis. And finally, everything I learned in one slide, tell me if I'm wrong, the logic of this stuff is not that we know what should be done about this problem. Yesterday we had a fascinating discussion on artificial intelligence, and many times we stop saying, shall we do this? Shall we do that? More regulation, less regulation, more precaution, more innovation. I think the logic is this one, that a true better regulation person says, I don't know what we should do, but I know the methodology that will take me to an answer. And that's the idea of challenging your priors, correcting your heuristics, doing foresight and listening to what the evidence says in impact assessment. We are not there as a community of those who work on better regulation to tell people what should be done, but what methods should be used so that we get to a decent evidence-informed proposal that can inform decision-making. And I think this clashes with the way the European Commission has become more political, because over the last few years, and it has been stated by the Commission itself that they are political. So they make a political choice for the digital transition, for the ecological transition, for health, for the chemicals, for you name it. And that means we know what the solution is. And maybe better regulation comes later at the level of the single legislative initiative. But so that's the way it is. It's not that I'm criticizing one thing or the other, but clearly that if you are political, you know what the solution is ex ante before you. If you are more of a better regulation person, you only know the methodologies, the raw procedures, the processes, I would say, the ways of involving the stakeholders, blah, 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 so that then you get to a decent proposal. I'll stop here. Thank you very much.
Professor RADAELLI, you have just proven that better regulation, better lawmaking doesn't have to be boring, as some people think that this is something we need to do, and then let's go on to business. But you have shown with many points how interesting and how many aspects is, and many of them really would be worthwhile discussing now in detail for hours, but of course we don't have time for that. But I got some ideas for new conferences. One of them is like this question of agility, which I think is very important. We get, we are very much in the system that we do it according to the book, but then also because of time frames, policy cycle is getting faster, and yeah, we're always behind. Huh? So we need to maybe think about how we build regulation on certain things, and we haven't started this discussion. We do have some questions, some possibilities for question. We're not completely Nordic with timekeeping here. Yes, please. There is over. Yeah, you don't have a lot of time, but some time definitely it's worthwhile.
Thanks. My name is Rolf. I deal with better regulation in the Swedish system. I have a question for Professor RADAELLI, and it also touches on other panels, I think. I agree with almost everything you said, but I think there's one question that's sort of unanswered throughout many our panels here, and that is basically the following. If we look at Foresight, I think it's easiest in a Foresight to identify high probability events, less easy to identify low probability events. If you're going to have policy coherence, you want to identify what's probable in different scenarios or between different policies, I think that tendency will tend to increase, that you will focus on high probability events. And then you have the situation, what is a crisis? I haven't really seen a good definition, at least not during these days, but I think it involves some element of it being a low probability event. We also know that, I think, that things like impact assessment tend to be less upheld in situations of crisis or low probability events. So there is some tendency perhaps that both foresight and impact assessment can be less available to capture the evidence necessary in crisis situations. So I wonder a little bit what can we do about this? And now I come to the difficult part of it. And this is a highly contestable proposition, but I attended a Commission seminar some time ago where it was argued that, in fact, crisis is what has been driving European integration. If you look at something like COVID, yes, it led to the Commission having an ability to raise money through borrowing, etc., and they also provided other examples. But if this is the case, then crisis is no longer just an outlier. It's a central phenomenon actually driving the European integration. In that case, we have European integration that is not well funded on either foresight or impact assessment. So I just wonder a little bit, do you have any comments on how to address this?
Okay. Yeah, difficult to answer quickly. I remember writing with a colleague a paper, Crisis, Learning and Policy Change, where we say that in a crisis, a fast-burning crisis, even your beliefs do not change fast enough. So you don't have the space in your mind to learn from what you see and change your beliefs about cause and effect mechanisms. And what you do, I know it sounds counterintuitive, you change behavior. So your mind doesn't change, but you do something. And if you think of some economic crisis, like the Deauville moment in the crisis of the Eurozone, where in 24, 48 hours, decisions were taken. And what is important in terms of better regulation principles is that, okay, so you respond often in terms of stimulus response mechanism, like someone thrown into the water cannot read a handbook of how to swim, but moves the body, behavior, and often stays afloat. It's to reason once you are out of water about what is it that kept me afloat in the water. So from anticipating likely costs and benefits to correctly reading and validating feedback, because nothing worse than reading the initial feedback from your behavior in the water wrongly and not validating it and persisting in the mistake. But certainly, if I was to put in a slogan, is more the better regulation thinking as a way of reasoning, thinking, validating types of evidence, than better regulation tools like let's stop 6 months and do an impact assessment of this. Plus, with foresight in theory, you have understood the mega trends, you have done the preparatory work, not the probabilistic anticipatory work I'm looking at Trish, if that's correct. But yes, okay. But the preparatory work.
Let's briefly also turn to our online community. As I said today, it's difficult to come here, so we have a good online participation, and I understand we have questions there.
Oh, hello. Yes, thank you very much. Well, we have quite a few comments and questions online, so I'm going to pick a few to make it concise. Just a couple of them. So the first one from Alexandra Berchetti. Would you see an EU law of administrative procedures applying to national administrations as well? And in your view, what would be the best interplay between national better lawmaking practices and EU ones in terms of coherence? Another one as well, this is from someone in EPRS, was asking, could you expand on your work on emotions and narratives about regulatory decisions? Because it's mentioned in your bio, and we have a colleague interested in that. And lastly, just a very, maybe difficult question, but a very short one. Is it possible to speed up the impact assessment process? Do you have any recommendations for that? Thank you.
Lovely questions. Worth another invitation, I hope.
I think we can work on that.
And anyone who wants to reach me personally with the email, it's in the last slide. I forgot to project it. With a thank you to Lorenzo Ali and other people who helped me. Anyway, yeah, I mean, the impact assessment in theory is done with the proportionality principle. So it can be light, it can be quick. When I was in Canada, assessment of a page and a half, but it was about whether to ban or not to ban wooden yo-yos. You know, the yo-yo is usually made in plastic, but Canada also had the wooden one that can be dangerous if the child swings the yo-yo on the head. So there was a number of potential risks. Obviously, the EU doesn't do regulations, or maybe it does, and I'm not aware at that level of granularity. So the duration of impact assessment depends also on what we stakeholders that never trust the Commission wants to know, because over the years, under pressure from the member states, we added a lot to the impact assessment template, including the competitiveness test, including the standard cost model for measuring the administrative burdens. Those were plugged exogenously into the toolbox upon request by member states that correctly, they want something, so they ask the Commission to do. So we found that in some countries where informality works well, having a heavily procedural impact assessment, it does not help at all with the quality of the business environment, with the perception of transparency. Is seen as a lot of sand into the system that blocks the system. So that's also another story I can say about different solutions for different groups of countries in the EU. And then whether the EU administrative law should also be a law. I'm not a lawyer, so I should not say what should or should not be done. I'm a good expert that every so often says, I do not know the answer to that. The third was in between these two. Was about the emotions. Again, just one word, administrative burdens, irritability, insupportability, the fact that it's not the burden itself doing a form, but the fact that if now we ask you to sign a form before using the toilet, you say, but why? You know, it's the lack of rationale that makes you very angry about not the 2 minutes it takes to fill in the form, but the very existence of the form.
Well, thank you once more.
Thank you.
I can only say yes, we see there's reason to invite you again, hopefully soon.